Well, good afternoon, everybody. Welcome to our webinar. I'm just seeing the attendees join, so we'll just give it a moment or two to allow more to come in. Okay, I think that'll do. We'll probably have others coming into the session. My name's John Mackenzie. I'm a partner at Shepherd and Wedderburn, and it's my role really just to welcome you all to this session. I'm going to introduce the speakers and try and manage the Q&A towards the end. There is a Q&A function, so please use that if you have any questions as we go through. If I see some interesting questions coming through, I'll maybe interrupt the speaker and keep them on their toes. We're going to hold some time for questions at the end, so we can hopefully have a bit of a discussion. Given the subject matter, we're not going to get into the basics of patents. This is really about the pros and cons of the two jurisdictions and the procedures that are available to rights holders. Patent litigation really is an arms and legs type of litigation. Almost anything can happen. Many issues will come up, and there are lots of avenues that we could explore if we had the time. So today is really just a quick review of the options available when you're at the early stages of a dispute. Your speakers today are Andrew McWhirter, who's an advocate at the Scottish Bar, and Andrew spends a great deal of his time on intellectual property issues. Also speaking is Rory Leishman, who's a solicitor at Shepherd and Wedderburn, and he also spends a good deal of his time on patent issues as well as other intellectual property disputes. So to make sure we've got time for questions, I'm going to stop speaking and hand over to Rory, who's going to take us through the first session looking at the options before the English courts. Rory, over to you.
Good morning, everyone. So just as a brief overview of what I'll be covering, I'm going to speak about the different procedural options in England, opportunities within them to accelerate the court process, different approaches to disclosure, and the cost regimes. So in England, in patent litigation, there is the option to raise a claim in the Patents Court of the High Court, the Patents Court, but within that using the shorter trials scheme, and also to raise a claim in the Intellectual Property and Enterprise Court, or IPEC. If we come to opportunities to accelerate the court process, within the Patents Court, the court will endeavour to have the trial within 12 months, but usually it will take up to about 18 months. Cases can be expedited if urgent, which usually results in a significant acceleration. And to give you an example, there was a case a few years ago that reached a full trial within 7 months. That obviously puts slightly more pressure on the parties and the instructing solicitors and barristers to collate their evidence and hit all the procedural deadlines. Within the shorter trial scheme, so this is it became permanent in 2018 within the business and property courts, and it operates in all of them, including those situated outside London. The aim of the shorter trial scheme is to achieve earlier trials for business-related litigation at a reasonable and proportionate cost. It tends to be most suitable for time-sensitive cases of moderate complexity requiring little evidence or disclosure, and where damages exceed those available to you in IPEC. It's not suitable for the most complex cases or any that involve allegations of fraud or dishonesty, for example. Key features of the shorter trial scheme include the aim of reaching trial within 10 months of the issue of proceedings, judgment being handed down within 6 weeks thereafter, limited disclosure, which takes an abbreviated issue-based approach, limited oral evidence, and the trial is limited to 4 days, including reading time. There's no limit on costs, no cost management, and no limit on damages. And it is possible to transfer in and out of the shorter trial scheme, including the court on its own initiative can suggest that a case be transferred into it. We turn to the Intellectual Property and Enterprise Court, IPEC. The IPEC was also designed to be quicker than an ordinary High Court case. Special procedural rules that override or modify the standard civil procedural rules, and they're designed to streamline the court process in an effort to reduce parties' costs. It's most suitable for SMEs with smaller, shorter, less complex and lower value claims. However, it has been somewhat of a victim of its own success, and cases can take 18 to 24 months to reach a trial. If we come to the different approaches to disclosure, as I started to touch on them previously with the shorter trial scheme, I'm fairly sure that you'll all be familiar with the process of disclosure. It's where parties identify and, if necessary, disclose relevant documents to the opponent. It can be a time-consuming and expensive stage in a litigation, and is often critical. And broadly, as you'll be aware, the obligation is to disclose documents that are supportive and adverse to the case being presented. And that's known as standard disclosure. In both IPEC and within the shorter trial scheme, there's no standard disclosure. And instead, disclosure requests are made at the procedural hearing by way of application, and therefore will always need approval of a judge. And it tends to limit the scope of disclosure, which in turn reduces costs and the amount of time spent on the matter. In the Patents Court, however, the obligation of standard disclosure is usually modified and largely confined to the alleged infringer producing a product or process description, known as a PPD. And that requires, in lieu of standard disclosure, requires the alleged infringer to produce full particulars of the product or process alleged to infringe. And that obligation is incumbent on both the defendant and its professional advisors in the same way as a standard disclosure process. Turning to the cost regime, in the Patent Court, there are no caps on damages or costs. However, for claims of less than £10 million, cost management rules apply, requiring parties to produce cost budgets. Within IPEC, subject to quite limited exceptions, such as if one side is deemed to have behaved unreasonably, the loser will not be ordered to pay total costs of more than £50,000 on a final determination of liability, and no more than £25,000 on an inquiry as to damages or an account of profits. And those caps are both inclusive of VAT. The overall cap is also subject to a scale cost regime, which limits the cost recoverable for each stage in the litigation. And I'm just going to pop a slide up that I'm hoping you'll be able to see if I double check with, share screen, and then I'm hoping that you can now all see that. So you'll see that table A on the left is the determination of liability, and table B is the determination of damages. And each stage of the claim has a maximum amount of costs that corresponds. Those of you who are good with arithmetic will have realised that the actual total comes to more than 50,000 and 25,000, but that's how the caps work. So each stage is capped with a total cap of 50 and 25,000. I'm just going to stop sharing now. So sorry, it's not possible to fully recover against all of the scale costs for each stage. Within the shorter trials scheme, there are no costs cap in cases within the shorter trial scheme, but nor are you required to submit a detailed cost budget as you ordinarily would in a standard High Court patent case. And the winner will usually recover reasonable and proportionate costs that are summarily assessed by the judge after trial following the parties' exchange of cost schedules. So it highlights the difference there between an ordinary patents case where you would have your full cost budget that you would seek to recover. In summary, I'll pop up another slide now, just to give you an overview of the options, and you should hopefully see that on the screen now. I'm going to see, yeah, I see my colleague nodding. So in summary, if you're concerned about speed and if time is of the essence, then the shorter trial scheme is best because you're likely to get a speedier decision and within a proportionate cost. If you're worried about an award of adverse costs, then the best option is probably IPEC because of the cap on costs. However, damages you'll see are capped at £500,000, so there is that balance to be taken into account depending on the size and nature of your claim. If you have a large claim and you're not concerned about an award of adverse costs or speed, then the Patents Court within the High Court is probably the best option. In terms of quality, there's no real difference between them. The IPEC tends to be specialised judges who are intellectual property judges. The Patents Court and the shorter trial scheme will be a High Court judge who, while maybe not necessarily an intellectual property specialist, is a specialist and experienced judge, and the quality tends to be the same across the board. And it would probably be more appropriate at the Patents Court if the case is complex with lots of evidence, multiple issues, multiple defendants, and you were seeking standard extensive disclosure. That would be more appropriate to go for the Patents Court. And I'll hand back to John now and look forward to your questions at the end.
Thanks, Rory. So that was a quick overview of options in England. I'm now going to turn to Andrew to tell us about Scotland.
Thank you, John. Yeah, so John and Rory have asked me to speak about the Scottish procedure for patent disputes. It's certainly, I would say, simpler up here in terms of the court structure. Really, patent cases are only raised in the Court of Session. They have to only be raised in the Court of Session. And I'll touch on what the procedure is in the Court of Session for patent cases shortly. But just by way of background, because I think this is reasonably interesting, at least from my perspective, there's relatively few patent cases raised in Scotland, particularly compared with England, but it's undoubtedly increasing, and it has been over the last few years. I say it's interesting because Scotland, in terms of IP registration, outstrips, and relatively speaking, outstrips England. I've managed to find IPO figures from, unfortunately not too recent, but going at 2019, showing that the percentage of patents granted in Scotland was up 4 points, or nearly 5%, whereas the UK as a whole saw a decrease of about 8%. So Scotland has I'm aware of many of your patent attorneys and will know this, but Scotland does have a greater relative proportion of patents being granted. But as I say, relatively few cases are raised in the Scottish courts. And I think that's a lost opportunity. And I'll come on to explain why. I think to begin with, it's probably worth just noting the jurisdiction of the Scottish court, because this is a point that I come across quite often. proceedings can be raised in Scotland if the infringer is based in Scotland, so that they're domiciled in Scotland, or if the infringement takes place in Scotland. The distinction is important. It was thought that the position was that if jurisdiction was based on the place of infringement, so the patent was being infringed in Scotland, so you raise proceedings in Scotland, but the infringer is not based in Scotland, then your interdict could only extend to Scotland. And your damages award could only extend to Scotland. So you wouldn't be able to restrain conduct in England. There has been some clarification of that, and a little, I admit, surprising clarification of that from the inner house of the Court of Session, which is the Scottish Court of Appeal. It was a recent case concerning Hendrick's Gin, which some of you might be aware of. Some of you might be aware of the case, many of you are probably aware of the gin. It related to a trademark infringement, as I say, and in that case, the Scottish Court's jurisdiction was seized on the basis of the place of infringement. Now, it was argued that the Scottish Court could only grant an interdict, a Scottish injunction, in Scotland. But on appeal, the inner house said, no, that's actually not right. The Scottish Court can restrain conduct in England and Scotland, provided that the infringer has a place of business in Scotland. And in that case, the infringer was Lidl, and clearly Lidl has a considerable number of shops in Scotland. But it's not, it wouldn't just be something like Lidl where there are shops in Scotland. If you had any place of business in Scotland, so I'm not talking about headquartered in Scotland, just a place of business, then you would get a UK-wide interdict and be able to restrain conduct in England and get damages arising from the UK-wide infringement. And that is quite a shift from the position that we all thought it was before. And I think that then opens up Scotland as a particularly interesting place to raise proceedings, but it does present some tactical advantages. Now, the most obvious tactical advantage, or the most obvious advantage, is if your client is based in Scotland, then it's likely that their witnesses will be based in Scotland, their advisors will be based in Scotland, so it would make sense to raise proceedings in Scotland. All the better if your infringer is based in England, because they will probably not have advisors in Scotland, they will probably not have witnesses in Scotland, so you seize an immediate tactical advantage, and you could potentially catch your opponent by surprise, and I'll touch on that later. But I think probably another potentially a general comment, but I think litigating in Scotland is generally thought to be cheaper. In some cases, it can be considerably cheaper than England. And the Scottish procedure, I think, encourages a speedy settlement more so than the English process. As I say, it's undoubtedly the position that many rights holders will only raise proceedings in Scotland if they feel they have to. They wouldn't elect to raise proceedings in Scotland. They would instead opt for the processes that Rory has talked about, IPEC and the Patents Court. And a recent example of that was a case concerning St Andrews University from 2019, where a case was raised in Scotland, and the other side, who were English-based, tried to argue that actually the case should have been based in England, should have been raised in England. And the Scottish court said no, there was a connection with Scotland. The university who raised the proceedings were based in Scotland, and it was not more appropriate that the proceedings should have been raised in England. So the Scottish courts heard the case. Now, what I think Rory has touched on, or has explained the various processes available in England, so the Patents Court and IPEC. As I say, the position in Scotland is considerably simpler. You raise patent proceedings in the Court of Session, and there are specific intellectual property rules in the Court of Session. There are specialist judges. There are 4 judges who sit as commercial judges who also hear intellectual property cases, all of whom understand intellectual property and have expertise in intellectual property. they will take a very active role in the case management. In fact, they can make any order they see fit in order to expedite the case. And I have been on, I have made use of that case management power quite recently in terms of expediting, for example, expert reports. We had a case very recently where I was acting for the defendants, and the claimant sought at quite a late stage to introduce new expert evidence in relation to damages. And the judge said, yes, you can, but I want you to disclose all of the documentation that you're disclosing to your expert to the defendant at the same time, so they can instruct their expert and review the same documentation. And you can have the two expert reports being prepared at the same time to mean that there's not a delay, or at least not as much of a delay as there could be. And with that, we were able to preserve the trial dates. But that wasn't just an example of the judge being quite proactive in terms of not having, say, 6 weeks for the claimant's expert report and then 6 weeks for the defendant's expert report, but to have the two running at the same time, with the defendant being allowed an additional time at the end because they will have received the claimant's report and may want to revisit what they're saying in light of that, but at least giving the defendant's expert a head start. In terms of procedure, what would broadly happen is you would have pleadings, which would be drafted in a very similar way to England. You would have the summons, which is effectively the same as the claim form, and defences, which should be lodged. The case would then call for a preliminary hearing before a judge. It would be the same judge who would take the case all the way through to trial. At that hearing, the judge will expect parties to have framed the issues in dispute, so narrowed the issues as much as possible, and will have lodged a document in advance setting out what they say the issues are. The judge can order further specification if necessary at that hearing. The judge can order expert reports be lodged at that hearing, and the judge can make orders in relation to recovery of documents. Scotland does not have a wide disclosure in the same way as England. The process in Scotland is much more focused. You request the documents you want to see. If the judge allows it, then the judge will order that those documents be produced. After that stage, the court will then call for the case will then call for a procedural hearing, where further procedure will be determined. And again, the judge has a wide power to make essentially any order the judge sees fit in order to progress the case. At that stage, the case will then be sent for substantive procedure, whether that be a proof, a trial, or a debate, which is a hearing on the legal issues. The one thing I think it is worth stressing is the tactical advantage that you can get in Scotland if you get if you're able to get an interim interdict. An interim interdict would stop infringement of the intellectual property right of the patent immediately, and they can be obtained very, very quickly and relatively cheaply. So you can have pleadings drafted into court and be up in court that afternoon or the following day, arguing before a judge that the infringer should be interdicted, should be prevented from infringing the right. If that's granted, then that interim interdict will remain in place until the case is finally determined or the interdict is recalled. As I say, it's very, very quick. It's relatively cheap. There's no need for witnesses to attend. There's no need for experts to attend. Sometimes you would have written affidavits as part of an interim interdict application, but often that's not required. In patent cases, you would want an expert report, I would say, generally, in terms of the infringement, just to make sure the judge is aware of the issues. But it's not necessary to convince the judge on the balance of probabilities that you're going to be successful. You just need to show to the judge that you have an arguable case. Sometimes, indeed often, these cases are heard without the infringer, the alleged infringer, being present. The alleged infringer only gets notice of an interim interdict hearing if they have a document called a caveat lodged with court. A caveat would be what we say triggered in the event that the summons is lodged seeking an interim interdict, in which case the court will then notify, or rather the court will require the claimant, the pursuer, to notify the defendant and provide the documentation, the summons to the defendant to allow them to come along and answer the interim interdict motion. That is the general position in terms. I would say that the majority of the cases I have, no caveat is triggered and the case will be dealt with without there being a defendant there. Often the court, in IP cases particularly, would fix a hearing in 7 days or 14 days time to revisit the grant of the interdict. In order to be addressed by the defender. I have had recently interim interdicts granted on the papers, so there'd been no need for a hearing, with the court then saying, "We'll come back in 7 days' time, and you can argue this substantively before me." But I say argue it substantively. We're talking about a couple of hour hearing, maybe a day hearing. We're not talking about a lengthy hearing with witnesses and experts. So it can be considerably cheaper. More importantly, it can give you quite a serious tactical advantage, because you then have an order from the court saying, "Stop this infringement now." You can serve that order on them immediately. And if they continue to do the infringing act, you can then raise proceedings for breach or committal, it would be referred to in England. What that often does is it encourages an early settlement, because the claimant, the pursuer, already has the upper hand. And quite often you can then at that point engage with the defender. You have your interdict. Although it's an interim interdict, you still have a court order, and there can then be discussions in relation to how to resolve the case. Now, as I say, the test is that you have an arguable case. It's not, as I say, not necessary to convince the judge to the standard of balance of probabilities that you're going to be successful. What you also need to do is you need to show that the balance of convenience favours the grant of the interdict. And this is usually where there's a bit more argument, essentially who's going to be prejudiced by the grant of the order. Often in IP cases, the reason why an interim interdict would be refused is if you have taken too long to raise the proceedings. So the infringer has been able to build an established business, for example. The court in that situation would say, "No, you've taken too long. I'm not going to grant the interim interdict. I will hear this case substantively. We can go through to trial, and I'll decide whether to grant a perpetual interdict at that point, or damages, and damages." But if you're acting quickly on discovery of the infringement, then there is a chance that you can get this order. And as I say, it is certainly a tactical advantage. And in my view and in my experience, it does encourage an early resolution. And it is, as I say, considerably cheaper, because you have you have a shorter hearing, you have no witnesses, you have no need for experts to attend. That, in my view, is really the primary advantage of litigating in Scotland. And perhaps in the question and answer session, Rory could if he feels he needs to rebut that, he can. I think it's probably worth also touching briefly on the disadvantages. Rory has explained the cost cap in England in IPEC. We don't have a cost cap in Scotland. So we don't have that level of certainty. If you lose, you are on the hook for the other side's costs. Now, not all the other side's costs. You would typically be ordered to pay 50 to 60% of the other side's costs, following a process known as taxation, where an account is prepared, and the auditor of court decides how much should be paid. But as I say, there's no certainty. You can't go into a case thinking, well, I'm only going to, if I lose, I'm only going to have to pay £50,000. You go into a case thinking, well, if I lose, I could be paying considerably more than that. Now, some see that, whilst that is potentially a disadvantage, some do see that as an advantage, because you may want to recover more than £50,000. If you're successful, you will be spending likely considerable sums of money on this litigation. So it might be that when you get to the end of it, £50,000 is really a drop in the ocean in terms of your legal fees. And that certainty of the cost cap might be something you're prepared to compromise on in order to recover more of your costs. Depends on the case entirely. There are proposals to introduce a cost cap into intellectual property litigation in Scotland. They did go before the Scottish Civil Justice Committee, who look at rules drafting, but that all rather got lost in the various COVID regulations that needed to come in, the new COVID rules, in order to bring in, say, remote hearings. So there hasn't been too much movement on that, but there's certainly the intellectual property bar in Scotland, intellectual property solicitors in Scotland are keen to have this cost cap come in. And it, not to apply to every case, but to essentially be able to elect that cost cap for appropriate cases at the outset of proceedings, in a similar way to choosing to litigate in IPEC over litigating in the Patents Court and the High Court. But that is likely some way off, but there are early proposals for that in an attempt to make Scotland a more attractive place to litigate. I do feel, just to kind of wrap up on that there are, as I say, tactical advantages, and I think the availability of interim interdict, which is cheap and fast, really is the main tactical advantage to litigating in Scotland. But as I say, it's important to act quickly if that is a remedy you're looking for. And if you delay and you let the infringer establish a business, then it's unlikely that you're going to be successful in getting that interim interdict. So you do need to act quickly. But perhaps the biggest advantage to Scotland is it is seen as being cheaper. And as I say, an interim interdict is certainly cheaper than running a full trial to try and get an injunction in England. Now, all of that said, I think it might be worth now going to the Q&A, and we can have a bit more of a discussion about the contrast and the approach between Scotland and England as part of that. So I'll pass back to John.
Thanks, Andrew. And there's a question straight back at you in relation to interim interdict. If it can be obtained so quickly, is it still a specialist judge who considers the papers and considers the argument?
It is, yes. These cases will always call before, or almost always. Certainly all the IP cases I've been involved in have called before the specialist judges, even at interim interdict. So almost always you can get one of the specialist judges to hear a case, either, as I say, that afternoon, the following day. I have heard stories of judges being, of cases being heard over weekends. I've never had to do it, but I believe it is possible to get a judge, one of the intellectual property judges, to hear a case over the weekend. I can't imagine they'll be too happy about it, but yes, the option is there.
You save up all your goodwill for calling out a judge over the weekend, and you don't do it lightly. Rory, just in relation to interim orders and interim injunctions, the impression Andrew's giving is that it's more difficult in England. Is that fair?
Yeah, I would agree. I think that is fair. It's a more substantive process that tends to be front-loaded. So in comparison to what Andrew described of being into court the next day and you have your pleadings and maybe no witnesses, no evidence, it would be standard in England to have witness statements and fairly detailed reasons as to why you would need your interim order, your interim injunction. It tends to be a more costly process because of that. And I think it's probably fairer to say that it's a different, maybe a higher bar or threshold to cross in England compared to Scotland to obtain an interim injunction.
Yeah, my impression is that the English courts are more inclined to consider the option of damages as an alternative remedy, and particularly in patent cases say, well, if we can see the product in action, then we ought to be able to quantify the loss, and therefore really all you're looking for is speed, and then point to the speedy trial process, which allows parties to litigate. But I think, to be fair, as Andrew says, you need to know what you're getting into, because the speedy trial process is not a one-day hearing. The speedy trial just means it's a great big trial, all compressed into a short time period. And you're going through the usual mechanics of witness statements if needed, and then expert reports and disclosure.
I think, John, it's worth picking up on it. The point about damages is a point that's argued quite frequently in the Scottish courts. Damages would adequately compensate here. Now, that argument will work alongside you have delayed in raising these proceedings type argument. The Scottish courts, the judges are reasonably receptive to an argument that it's very difficult to quantify damages in IP cases. And actually preventing the infringement is a better remedy. It's not to say that they will, in every case where you raise it quickly, they will grant an interim interdict. There will be an argument about who will be more prejudiced. There may be an argument about the strength of the case. But certainly my experience is that interim interdicts are frequently granted on the basis of, I mean, they will be granted on the basis of the pursuer's pleadings. And the judge, as I say, will be receptive to an argument that it's very difficult to quantify damages if this case was to go through to conclusion. The other point, just to raise very briefly on interdict is, and I should have said this when I was speaking earlier, you can get, the other side can get damages for wrongful interdict. So you do need to be careful about applying for an interdict. You need to have a basis for doing so. Because if it turns out that you should not have got that interdict at the end of the day, then you may be on the hook for the damages as a result of the fact that they won't be the infringer by that stage. The defender should have been able to do the act that you were complaining about.
Yeah.
Yeah, that's Andrew slightly beat me to it. I was going to mention that, and in England as well, if a cross undertaking in England to compensate what would then no longer be the infringer is not sufficient, then it's unlikely that the court would grant interim injunctive relief. But you can be on the hook as well in England for wrongful interdicts. You obtain an interim injunction at your own risk, effectively.
Okay, I just want to pick up on something that was discussed and is mainly an English concept, which is cost budgeting. And this is really a question for Rory. And maybe I come back to Andrew to comment on why Scottish courts might be looking to introduce cost budgeting. But Rory, from your perspective, how effective do you think cost budgeting actually is? And maybe start with some mechanics of how does it actually work? What does cost budgeting actually mean?
Okay. As it suggests, as the name suggests, you prepare a budget for each stage of the litigation, and you outline the hourly rate of the solicitors and the number of hours that you expect each solicitor. So, for example, John's a partner, I'm a solicitor, it's different hourly rate, and you would outline the amount of time anticipated for each stage, and including junior members of staff as well, such as a paralegal or a trainee, and also for counsel, so your barrister, either team or individual barrister, and each stage is costed, and a breakdown of the full costs through to trial, and you can build in contingencies within that, and assumptions. So, for example, you can build in a contingency for one application in England and give a figure. You can also build in assumptions surrounding the length of the trial, for example, or the number of witnesses, and that can, and so that maybe leads into the effectiveness point, in that you can make these assumptions and you come to a final figure, or you can build in contingencies. But those of you who have been involved in a litigation will know that it's organic and things can happen that you perhaps haven't anticipated, or the other side can do something that seems a bit of a curveball, and that can make costs escalate. Another maybe point on the effectiveness is that I don't think I've ever seen a cost budget come down. And I don't know if John has either, but in England, and it tends to be something that would go up in my experience. So as far as effectiveness, it's something that while judges in England are much more hands-on with managing the procedure and the case, which is maybe something we'll come to, they tend to, if the cost budget seems reasonable, and especially if it's very close to the other side's cost budget, the judges seem to approve them, and they tend to just only be revised upwards as the case progresses.
So I think Rory's gone on mute, finished that point, but I'm going to pick up from him to say that it spawned a whole industry of satellite litigation around cost budgets, and there is almost a separate profession of costs draftsmen whose job it is to assist the drafting of these budgets and then to argue the budgets. What I find tends to happen, and we had just had a recent experience where we exhibited a draft of our budget for the purposes of mediation before the actual formal deadline for a cost budget, and it was quite a large sum of money broken down into various phases. Then it came to time for exchanging cost budgets formally, and lo and behold, the other side's cost budget was almost exactly the same as ours. The point really is that I suspect if they saw our figure and thought, well, that's more than enough in terms of covering what our recoverable costs are going to be, then we may as well put that number in. There's no point in pitching low when it comes to cost budget. And my own personal concern is it leads to a spiraling upwards of costs rather than actually applying any real pressure for costs to come down. It does give visibility and certainty of at a very early stage of what the other side is intending to spend. And if you're up against an opponent who is a big spender, at least you know that at an early stage, and you can, if it looks to be wholly unreasonable, appeal to the court for some protection. And the courts have been quite vocal when they've seen extreme examples. Andrew, do you think it's...
Oh, sorry, I was maybe going to just add one final point, sorry, John, that I think from a commercial point of view for the client, cost budgets are quite useful, even if only that by breaking it down stage by stage and mapping that against the procedural timetable. For example, if you're working with a big client with a CFO, the CFO can then plan their cash flow throughout the financial year and maybe realise, well, there'll be a lull in the litigation at this point, and the budget looks as though it'll be slightly less for that month. But as we get towards, for example, expert reports, and I know I'm going to have an outlay for the expert, then they can plan accordingly. So they are quite a useful discipline for certainly the client.
Andrew, what do you think we're ever going to have cost budgeting in Scotland?
Very good question. I think you have very properly addressed the difficulties with cost budgeting, which is the satellite litigation, the fact that you can actually end up spending a lot of money arguing about your costs. And I think the Scottish courts and those responsible for drafting the rules have looked at what's going on in England and have gone, I don't know if that's entirely desirable. we at the moment don't have cost budgeting, and I'm not aware of concrete proposals to bring it in. There are advocates for it, there are advocates against it. I certainly, from my experience of it in England, feel that it is a process by which you build in assumptions, and often those assumptions are wrong. But I completely appreciate Rory's point, which is that it gives the client certainty, and it gives the client certainty in terms of a degree of certainty in terms of spend at particular points, and you will see where there are particular areas where there's going to be a lot of costs incurred. That is probably something that should go on within firms with their clients anyway. But the difficulty is once that gets put into the forum of the court, then it does spawn satellite litigation. It does build up costs, arguing about how much money parties should spend on the case. The Scottish approach is, if you get an award of costs at against another party, then you can either agree that, or you can put it to the process known as taxation, where the officer of court will decide how much should the paying party should be ordered to pay, which is based on relatively complicated tables in terms of what various different stages of the case are worth. And it is possible to get an uplift on costs in Scotland in complex cases. Now, patent cases are almost always complex, so usually it's a relatively easy argument to get an uplift, but it's not going to be a large sum of money in terms of the uplift. I think it's probably fair to say that cost recovery in Scotland is less generous than cost recovery in England. You will probably recover a lower percentage of what you spend, but come back to the point that in Scotland you will spend less.
Okay. Now, encourage participants to jot down any questions they might have in the Q&A section. But I've one or two, probably picking up on something Andrew said about expert evidence and the powers of the court. The question is, maybe we'll start with Rory. How does the court control expert evidence? I say this from the perspective of a Scottish case where there were 10 experts involved in the case because the parties, well, I'll not say any more about that case, but Rory, how do the English courts control expert evidence?
Yeah, in England, I think, as I'd said, the judges are much more hands-on and involved in the case management. And the starting point in England is that you require permission to lead expert evidence. So immediately you've got to justify why you need the expert evidence. And I have had some cases where one springs to mind, is not a patents case, but where our client and we felt there needed to be an expert, as did the other defendant, but the claimant didn't. And then it becomes a decision for the judge to determine. And then within that, there are some other requirements within the procedural rules, such as a presumption for a written report, the requirement that what is actually laid as expert evidence is that which is reasonably necessary or reasonably required to resolve the proceedings. So to sort of summarise the position in England, you need to justify why you require an expert, and the court must grant you permission for however many experts you wish.
And Andrew, what's the position in Scotland?
I mentioned that the judge has a very active case management role in Scotland too, and I have had cases where we have had multiple experts instructed and the judge has said, do you really need these multiple experts? And the judge can make orders as to who can give evidence and who can't give evidence. So the judge could exercise a control over expert evidence if it appears that experts are unnecessary. The Scottish courts have, and I think it's the same in England, expert reports will form the examination in chief, so that cuts some time out. You will have to justify to the judge if you want to ask further questions. We have in Scotland. And again, this is a position in England. You have what's known as hot tubbing, where the experts will all be in court at the same time and will be asked the same question, and the judge will listen to each of their different interpretations of the question, or the different answers to the question. The Scottish court in IP cases will almost always, without exception in my experience, order a joint meeting of the experts before the trial. At that joint meeting, the experts need to identify the areas in which they agree and disagree, and that can help to frame the issues before the court for the trial. And again, it's a point where the parties will look at their case and look at the strengths of their case when the two experts have met and discussed the issues that they think are in dispute. So all of that can significantly cut down the amount of time that the experts are required to give evidence for. But I fall back on, it's all about the court's case management power. If it looks like an expert is unnecessary, then move to have that expert's evidence excluded, and the court will entertain that.
Okay, I'm conscious of the time. We're coming up to the end of the allotted session, so I think I might finish on the old chestnut that we've been grappling with for the last 2 years or so. But it's an issue that seems to be bubbling up quite furiously in the European Patent Office in relation to hearings, and it perhaps isn't as dramatically impactful in a small jurisdiction where people are relatively close together, but for issues where hearings are being held in Munich, for example, the use of remote hearings makes quite a dramatic difference to the way in which who can engage and the cost of engaging and so on. So the open question is what's happening in the Scottish courts and the English courts. And Andrew, do you want to take Scotland?
It's a big question. What's happening at the moment? The procedure is that all procedural business, I mentioned preliminary hearings, procedural hearings, and pre-trial hearings will all be done remotely. And I think that's going to be the position going forward. That's certainly the position that the judges are keen to adopt. The substantive business, there will be now a presumption in favour of that being in person. So a trial will be in person. The Scottish courts, particularly the courtrooms that deal with these types of cases, will have now all been set up for hybrid cases. So you will have to say to the judge, this witness will need to give evidence by video link, but the courts are now set up to do that, and I think you would need a pretty compelling reason to say, no, I don't want that witness to give evidence by video link. The judges have not been receptive so far to an argument that it's better to do it in person because it's easier to cross-examine, or it's easier to get a feel for the witness's credibility or reliability. That's not something that's being entertained. There would need to be a better reason than that to object to a witness giving evidence remotely. So it does seem to be the position that hybrid is going to be the way forward. And I think that is correct. John said it's a small jurisdiction. It may be that a lot of the parties are close together, are all based in Scotland. But you also, in patent cases, would frequently be instructing experts in other countries because they have particular expertise that you require for your case. And it may be easier to have that expert give evidence remotely rather than flying them across. It will depend on the case. It will depend on the expert.
Rory, do you want to pick up on England?
Yeah, I think it's fair to say that maybe the English courts were quicker out the blocks during the pandemic and happy to move to remote hearings. I did see something that came out the tail end of 2021. There's been some government evaluation, and I think it was around 50% of judges thought that remote hearings worked very well, certainly for certain types of procedure, and I think certainly for procedural hearings they've been effective, and as Andrew says, certainly for certain types of witnesses, such as experts, where there's unlikely to be an issue around credibility or reliability, and there's travel costs involved, then they work very well. And I'd hope that they would continue with the option to have a hybrid format where, for example, you might have barristers in the court with the judge and the clients and certain witnesses, but it would be open to call the expert remotely. I think one issue, I suppose, is sort of an access point of view, like you made, John, of who can actually access the hearing. I think sometimes we forget that it's a public court, and albeit within patent cases, there's quite often an element of confidentiality. But yeah, my impression and my understanding, certainly in England, is that the technologies there exists and probably here to stay in some form or other.
Okay, and I think we actually have a punchline question to finish on. And this is coming your way, Andrew, given that you've talked about the Scottish process being less expensive. But the question is summarising, I think, effectively the presentation, which is that a hearing a case at the IPEC is the cheapest option. I think it's fair to say, well, it's an option that has limits on damages and awarded costs. The important point is you're still paying your own fees, and the IPEC doesn't limit your own fees. The limit is on what the other side might claim back from you. Then the relatively easy availability of interim interdict in Scotland promotes early settlement and so restricts costs. Correct. I think that's a point coming through. But the punchline question is, how do the costs compare for a full trial in the Court of Session against the Patents Court in England? Now, if anybody is feeling brave, Andrew, feeling up to answering that question?
Yeah, well, I think Scotland will be cheaper. I do think Scotland will be cheaper, but it comes down to, I've mentioned the issue of cost recovery as well. I think Scotland's less generous. But my experience of litigating in Scotland and litigating in England is that it is cheaper in Scotland to take a case all the way through to trial. It's still very expensive, but yes, it's not. That's my experience, and I welcome John, your views and Rory's views.
Yeah, I think from my perspective, it's difficult to say because it really does depend on the case, and you can find yourself spending hundreds of thousands of pounds in Scotland, which would never fall within the definition of cheap. But equally in England, you'll see I've seen public documents that saying a patent trial in a patent case in England will cost you at least £800,000. Now, it really does depend on the circumstances of each case whether that same case will cost as much or less in Scotland. And I think it's quite a tricky question. So it's probably one to, it's perhaps an unsatisfactory finish, but it depends. But hopefully what this session has given you is an overview of the options that are available. And just drawing that together, you've got a number of procedural options in England that come with challenges and costs. Perhaps fewer options in Scotland, but come with opportunities for restricting your costs. And I think I'll perhaps by finishing on that, if you have any questions, please ask, please follow up, and either myself, Rory, or Andrew will be delighted to follow up separately. Finally, thank you very much, Andrew. Thank you very much, Rory, for your time and taking us through the questions, taking through this what's a tricky subject matter. And thank you everybody for attending. And we'll bring the session to a close now. Thank you.